Good afternoon, everyone, and welcome to the webinar, Evidence-Based Prosecution of Intimate Partner Violence. My name is Katie Douglas. I am a legal assistant at Equitas, and I will be moderating today's webinar. If you have a question during the presentation, please enter it in the question and answer box. We will answer questions periodically throughout the webinar. You are also welcome to contact us directly at any time following today's presentation, and we will send you contact information during our follow-up. Equitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. As a national training and technical assistance provider, Equitas develops resources, conducts trainings, and offers 24/7 consultations for prosecutors and allied professionals. For more information on Equitas, please visit our website at equitasresource.org. You can also follow Equitas on X, Facebook, Instagram, and LinkedIn. The link to each is available on our website. You can also find information about our projects and special initiatives on our website. Today's webinar is supported by the U.S. Department of Justice Office of Violence Against Women. The information presented in this webinar does not necessarily reflect the views of the Department of Justice. This presentation includes the creative work of others. This property is being used by permission or under claim of fair use, and further use or distribution is prohibited. And now I will turn it over to our presenter, John Curlin.
Katie, thank you for that introduction. Thank you everyone for joining us today for Going Forward Without the Victim, talking about evidence-based investigation and prosecution of domestic violence. Now, we only have 90 minutes and a lot of stuff to cover, so I'm going to jump into it pretty quickly. But I do want to give you a little bit about my background, just so you have some context about who I am, other than my name. It's John Curlin. I work as an attorney advisor with Equitas. I've been an attorney advisor with Equitas for about 7.5 years. Prior to that, I worked for close to 20 years as a prosecutor in Pennsylvania, primarily in the area of Berks County. Now, if there's folks who aren't from Pennsylvania here or you aren't familiar with the county geography of Pennsylvania, Berks County is primarily known for the city of Reading, being the home place of the best snack pretzels in the world, as well as the birthplace of Taylor Swift. So there's our trivia for today. Berks County is a pretty interesting jurisdiction to grow up as a prosecutor because it's really varied. The city of Reading is pretty urban in nature. It's surrounded by suburbs, but after that, it's very rural and has traditional Amish communities and old order Mennonite. And as a prosecutor in Pennsylvania, I started off doing the line things that most prosecutors do and getting to have chances to do lots of trials. And I specialized in various areas as like in the appeals unit. I worked as a special assistant U.S. attorney for a bit. But really, the kinds of cases that I found most rewarding and most challenging were cases with the most vulnerable victims. And those are child abuse cases, intimate partner violence cases, sexual violence cases, and homicides. And those can be tough cases as well as rewarding. And looking for resources about how to do these cases better and just sort of build up your skills was really difficult until I found Equitas and had a chance to work with them. And that's an invitation I extend to everyone here. You're probably really knee deep in the work here. You're looking for resources, you're looking for ways to brainstorm ideas. Please don't hesitate to reach out to us at Equitas. We're here to assist and help you. Katie described a little bit about what we do with the nature of consultations. But if you just get a novel issue, you sort of want to get a vibe, maybe how it's handled in other jurisdictions. Look at different ways you can approach the problem in different facets. You want to get sample transcripts or motions or briefs or things of that nature. Reach out to us. Don't hesitate. You can reach out to me directly. My contact information is in the materials and at the end, or to our general resource email. All right, so how are we organizing today's presentation? Well, one, evidence-based prosecution is based on that idea, what happens in that intimate partner violence case when there's a victim who isn't able to participate. And by not participating, I mean that they are not testifying or they are testifying, but they're recanting or minimizing. How can we still try to get justice for that victim, keep them safe, keep our community safe from the offender, and also hold the offender accountable? Well, one of the things we do want to talk about is look for ways that we can hopefully facilitate or encourage victim participation by understanding some of the barriers that they're facing and looking for strategies that we can use to mitigate that. Reality is, though, in the nature of domestic violence and intimate partner violence dynamics is such that even with the best of practices, the reality is that a lot of victims, even after those efforts and resources that we should do for their own sake, still might not be able to participate in a prosecution. So we want to talk about investigative and prosecution strategies that can build a case that doesn't have to rest on the victim's shoulders about whether or not we can go forward. Similarly, how we make those decisions in homicide cases about how can we go forward without the participation of a victim, we want to sort of apply some of those tools to when a victim has not been killed or deceased, but just isn't able to participate, usually because of things like offender intimidation, manipulation, tampering, things like that. Part of a big strategy to do that is look for ways we can build up our case when the victim isn't going to be a participating witness at trial. And that means trying to identify those sources of corroborating evidence and working in a multidisciplinary fashion with our partners in law enforcement so that we can identify those kinds of evidence at the investigative stage, so then we can bring them into the prosecution stage. All right. So I assume that we have a big audience here. We're at 72. So I want to start with what might seem like sort of a rhetorical question, but it's not meant to be a trick question. But sort of let's just start at square one here and ask ourselves, when you have an intimate partner violence case, and there's folks here who probably working with these cases daily, with a little bit of experience, we're often getting some indicators that the victim is not going to be testifying or that they're going to be minimizing or recanting. And let me just ask if folks can join us in the chat window and just talk about a little bit about what are some indicators you see that a victim might not be testifying. And this is sort of a way to hopefully make it more. They immediately ask how to terminate the no contact order. I'm assuming that's what the NCO stands for. They have an immigration issue. They ask to withdraw charges. Thank you, Alexander. I love it when they actually are straightforward with that. You're listening to jail calls. The victim no-shows to meetings. That's a contrast, I think, to what Alexander was talking about when you just get the ghosting effect. They say it wasn't that bad. You get the minimization. So they say they made up their earlier statements, and so there's a recantation. These are clearly those kinds of indicators. And someone who said that they just outright tell you, sometimes that's sometimes missed because as a prosecutor, I was kind of surprised when a victim just blatantly told me they don't want to testify, because usually it would be either a surprise on the witness stand, or it would just be as being ghosted by them. They wouldn't respond to phone calls. I couldn't find them. They were missing appointments, things like that. You're finding that there's post-crime contact with the offender. Maybe we're just learning about that in jail calls, but I don't think we should think that's not happening when the offender's not in jail. Of course, it's regularly happening. And I think that's a big sort of the reality of this intimate partner dynamic of a crime. I mean, if there's a strong arm robbery of someone random, probably the only reason the offender isn't having contact with the victim is because they're a stranger. They don't have access to them. But with an offender who's victimizing someone they're in an intimate partner relationship with, in a domestic relationship with, they have access to that victim. They have shared history, they have shared life, they probably have a shared house. And so there's a lot of opportunities just through everyday reality for that offender to be having contact with the victim and start working on them, first a little bit and then a lot. We find out that they don't want to testify where there's a recantation or minimization. The other times we sometimes get a clue is maybe when we're looking through the rap sheet or we pull up old police reports, we see a lot of null pros or charges withdrawn or victims said they didn't want to testify. And while we're not brokers or anything like that, we're looking at past performance as an indicator of what's going to happen in the future. I just glanced over at the chat window here. The defense attorney tells me the victim is pleading the fifth, and that often would happen here to me. I sometimes had a question about how my defense attorney friend would know that. I suppose the benefit of the doubt is that the offender told them, because of course the regulation or contact with unrepresented parties should be is a regulated thing. So let's talk about why these victims do this and why that this happens. And these are the results. So the victims tell us what they don't want to do. This can lead to greater traumatization. But these victims that are essentially products of attrition through these cases, and this is a big reality in intimate partner violence cases, and it can be frustrating. And the natural reaction can often be to, instead of getting frustrated with the defendant for putting these events in motion, is to be frustrated with the victim because that's the person most right there. And you'd have to be a saint and probably more than just someone with human reactions if that doesn't bother you at some point or at some level. But I think sometimes when we do that, it's we can sometimes sort of forget these challenges that victims are facing in this dynamic. Because a lot of times in the intimate partner violence cases, a victim's willingness to participate means abandoning a lot of things they know for an unknown. And I think a lot of victims are almost in a position of the devil they know is better than the devil they don't know. And at the same time, they're isolated. They don't have a support system. Usually, that isolation is a product of a sort of domestic violence history that's been cultivated and groomed over a period of time. They've been isolated from friends, from family, because the offender is trying to control, an abusing offender is trying to control so many aspects of that victim's life. There's really practical considerations a victim is going to have for participation too. As a prosecutor, I always thought, hey, victory is if I can get that conviction. And that is one component of success as a prosecutor, but it's a limited perspective and not very holistic. There's a broader sort of range about how we can judge success. But for a victim, if that offender is convicted, then what happens to the partner who's going to help care for children? What happens to income? What happens to housing? What happens to all these things? A lot of victims, a victim in any kind of criminal case is victimized on some level because there's a real or perceived vulnerability that an offender exploits. And domestic violence victims definitely are having vulnerabilities that make them more subject to this cycle of abuse from an offender. The other reason why it's sort of challenging and can be so difficult to understand or not get frustrated with the victim is from our perspective, when we're coming into the case, it's really episodic in nature. There was a 911 call, police responded, they found out what happened. But one of the things we want to talk about and understand about domestic violence dynamics is while we're getting a snippet of the story, maybe a chapter of the story, or a still of the movie, this cycle or escalation or evolution of this domestic violence dynamic, it's been evolving over time, far before police ever stepped into the picture or we as prosecutors may have stepped into the picture. And so if we don't try to appreciate the history or context that happened before, it can be really difficult to understand why victims are behaving or responding or reacting that the way they do. And especially even in our prosecutions too. If we can't try to widen this lens about what's happening to this victim, it's going to be harder for jurors to understand what happened. A lot of times, and this is the nature of the criminal justice process, we have a real good tendency, and I'm not saying it's something we neglect or should throw out, a really good ability to sort of take the magnifying glass and zero in on the details of an episode. But the way we are sort of systemically set up, it's a lot harder to sort of widen that lens and get a bigger picture of what's happened to this victim and what this offender has sort of gradually and perpetrated against this victim in an escalating manner. So, with this in mind, and with the understandable frustration that happens when victims can't participate, I think what we really want to do is we want to keep our goals in mind. And instead of sort of recognizing victims as our barriers, we want to sort of recognize them as these are the people that we want to help. Help can look a lot of different ways to different victims. And we want to sort of be open to that. And it might be more than what our sort of short term or shallow goals are of just getting the offender held accountable. But what we want to be doing is looking for ways to support victims, even if they're not going to be participating, even if they still recant or minimize. What are some other resources we can give? What are some ways we can cultivate trust so that they're not going to see us through an adversarial lens the next time they're coming into the case? And we want to look for ways that we can hold offenders accountable as best we can, not just for the victim's safety, although these victims are an incredible amount of danger, but also to keep the community safe. Because the domestic violence offenders, these are some of the most dangerous folks that are coming through our door. And these are some of the most dangerous. They're not only dangerous to the victims involved, they're dangerous to children if there's children in the environment. And of course, statistically speaking, most people, most officers who are involved in officer-involved shootings, most mass shooters have a domestic violence history or there's a domestic violence context. Now, I'm not trying to say every domestic violence offender is going to kill a cop or become a mass shooter, but I am saying most mass shooters or people involved in officer shootings have some sort of domestic violence history, which what makes them so dangerous. And I just want to make another note about terminology here too, while we're talking about looking for ways throughout this presentation. And this is something I sort of grew to. This isn't something how I originally started. Usually in intimate partner violence cases, you won't hear me describing victims who are cooperating or non-cooperating. I usually am sort of framing victims who are participating or not participating. And the reason for that, and the reason why I use that language, and I'm not trying to cancel you or be a language cop if you describe a victim as cooperative or uncooperative, that's fine. I'm just sort of want to explain my thought process behind it, and maybe folks might want to adopt it. Um, but the reason why I don't talk about victims, domestic violence victims, as being cooperative or uncooperative, because cooperation really implies a choice. And when you think about all the barriers and challenges that victims have, an independent choice of cost benefits isn't something a lot of intimate partner violence victims can do. Now, cooperative is a great way to describe if I've got a co-conspirator burglary or robbery of a place and I'm trying to flip the lookout, I'll describe that co-conspirator as being cooperative or uncooperative. But I don't think it's the best language to describe what's happening to my intimate partner violence victims. Instead, that's why I like to use the word participate, because it talks about their ability to do something. And sometimes it also helps me think about what are ways I can sort of maybe helpfully facilitate them being able to participate as best I can in an imperfect world. All right, so let's talk about some of the mechanics. Really, what is here in the title of this presentation, building an evidence-based case. And what do we mean by evidence-based? And folks, you probably use this terminology and are familiar with it, but I always sort of hated it, but this is what we're stuck with as a term of art. Evidence-based prosecutions is that idea of building and presenting a case in which prosecutors can hold offenders accountable for what they did with or without the victim's testimony. Now, as a term of art, this sort of language always sort of annoyed me because as a prosecutor, I'm like, all my cases are based on evidence. How is this any different? Nevertheless, this is the language we are using, and this is what we mean. How can we build cases, domestic violence cases, intimate partner violence cases specifically, that aren't dependent on that victim's testimony or that victim's ability to participate? And these are the strategies we want to talk about. And I think if we want to distill it, and we're going to talk about specifics as we proceed through this presentation, but a lot of the ideal strategy for this evidence-based prosecution practice that we're talking about or speaking about in this context is really a murder case, a homicide investigation, because those are cases that we look to hold an offenders accountable without a victim there to participate. And I don't want to say categorically, but generally speaking, investigative and prosecution case practices are pretty good in murder cases and homicide cases. Our investigators are pulling out all the stops, they're canvassing the neighborhood, they're talking to everyone they can, they're trying to follow as many leads. As prosecutors, we're hopefully getting the benefit of being able to prep and spend time with it and build it up. And in an ideal world, we would be able to expend that amount of time, effort, and resources for every domestic violence case. And I say in an ideal world because in reality, with the limitations on resources, that would be impossible to do. But really, even if we can't get to that ideal of a homicide investigation or a murder case effort, in a domestic violence case, we want to be talking to our other stakeholders in law enforcement and advocacy and talk about ways we can get as close to that standard as possible in those cases. How can we build a case up from the ground floor that's not going to have to rely on the victim's testimony? And we might want, in different communities, might make different decisions about how to triage that prioritization. Maybe if there's a strangulation, that's something, yeah, we're going to like work to see how we can hold this case as successfully in front of a trial if we need to, even without that victim's participation, because there's so much safety concerns. It's so dangerous. And we know strangulation occurs in a more sort of escalated stage of a domestic violence dynamic. So it's more likely the victim isn't going to participate because it's at the later end or more evolved end of a domestic violence dynamic. Maybe when we're having a domestic violence offender who has lots of cases that's dismissed, or where the victim is been a product of attrition, that might be something we want to more highly prioritize with a wider or more intense investigative and prosecutive effort so that we can hold them accountable. So building the evidence-based case necessarily requires, and I apologize for the fancy animation here. Oh, sorry. For the fancy animation here, it necessarily requires evidence, which is something that speaks for itself, as we can recognize. But what I mean by this is when we're looking at a case and building a case is sort of the antithesis of this evidence-based prosecution is an investigation where the responding officer responds to the scene, they get a statement from the victim, they maybe get a statement from the offender, and that's it too. But instead, what we're really talking about with an evidence-based investigation is really what we should be doing in every kind of prosecution, but we're looking for ways that we can find evidence that is going to help us establish the elements of the crimes that happened and that we can charge, that are going to be, we're looking for evidence that is going to give a wider context to what happened. So in other words, we're not just looking for evidence that can tick off a box for an element of a charge, and we're also looking for evidence that can explore potential defenses and potentially also combat or negate those defenses as well. So in this things, what are sort of the different prongs or buckets we want our evidence to fill? Well, we want to find out ways, how can we prove injury happened to the victim? How can we find, are there photos of injuries? Are there descriptions of injury? Is there medical care that was administered? Are there observations of injury? We want to look for statements about what happened, statements from the victim, statements from the offender, statements to as many individuals as possible, not just to our responding law enforcement people. We want to find out what other people know about the context of what happened. And ideally, we're trying to explore the case, not just with that Google Street level view, but we're trying to explore the case and the dynamic with that satellite view to get a bigger picture of not just what happened in the specific incident that was responded to, but what's happening over the course of the relationship. We're looking at the crime scene that happened. How does that speak? What does that look like? How does that corroborate the crimes that may have been proven? What does demeanor tell us? How are we recording that? And also, we're looking at the prior history. One, to sort of inform us about what might be happening in this case or in this specific incident and to sort of tune our antenna. But also, we're looking at the prior history because we want to get an idea of the bigger picture here. We don't want to mistake trees for a forest. We want to be able to see the forest rather than a specific tree. and understanding the prior history, whether it's a prior criminal history or just their general history with each other, can tell us more. Now, I usually prefer giving this presentation with someone from law enforcement because of this next piece. Because as a prosecutor, this doesn't always land with well with law enforcement, but nevertheless, it's a reality, and it's something I want to emphasize. And really, it talks about how important our law enforcement partners are. And to sort of set the table for it, I am going to reference a Duluth police domestic abuse policy, the Duluth police out of Minnesota. And a decade or more ago, they sort of took stock of their domestic violence practice and they tried to develop best practices in doing so. And one of the things that the police agency in Duluth recognized is that a lot of the success of intimate partner violence cases, but especially evidence-based prosecution of intimate partner violence, was largely dependent on the investigation that happened at the outset of the case. That really set the tone and the foundation for almost everything that happened after, and was really the sort of the cornerstone or keystone, if you prefer, about what happened. And I don't know how many law enforcement friends are in the audience today, or if it's really just a lot of prosecutors or maybe advocates. But this is really why sort of multidisciplinary collaboration is so important, so that we can be having conversations with our law enforcement partners and let them know that, hey, like, look, with this a kind of fulsome investigation that we can do, or as fulsome as possible an investigation in an age of limited and stretched resources, the more opportunities there are on the prosecution side to take this case forward, even if victims aren't engaging, even if they can't participate, even if they're not testifying, even if they're recanting, and even if they're minimizing. So this isn't really a evidence-based crime scene processing course, so I'm really going to be summarizing a lot of it here. But what does that sort of fulsome investigation mean of this intimate partner violence case? This means trying to photograph or video record the crime scene. I think this is a lot more able to be completed today in modern times than when I started off in the late 90s and early 2000s, just because of the ubiquitousness of body-worn cameras. The documenting the demeanor, again, everything being videoed sort of makes a demeanor, but also preserving statements and getting them memorialized. I know when I started practicing, whether a statement would be memorialized would be a sort of flip of a coin. And when they were memorialized, it was usually something like written statements, which is not a really trauma-informed way to preserve a statement from a victim, but it was something memorialized. Now, with just how common video is, hopefully it's a really easy way to preserve statements from victims, from third-party witnesses, from the offender, from everyone on the scene. But we want to try to be also building a better investigation by finding other witnesses to the case. Even if an assault, the only people present during the assault were the offender and the victim, there's other witnesses we can use that can give the context and history of the relationship, what happened before the assault, what happened after the assault. And it's these witnesses we want to identify and talk to and preserve. We want to be looking at that offender action both before and after and really sort of zeroing in. And of course, and I think it can almost go unsaid, always be looking for those digital investigations. What's on the phones? What's on the router logs? What's on the Internet of Things? What's on the Alexa speaker? What's on the wearable devices that they might be wearing on their person? All these things can help build timelines, corroborate disclosures, and build cases that aren't going to be dependent on victim participation. Other sort of things we want to be thinking about evidence collection is, of course, preserving those 911 calls when the incident comes in through a 911 call, getting statements from as many people as possible, looking at the crime scene, interviewing the kids at the crime scene. And look, I'm not trying to say you should have a bright line rule that anytime there's children who witness domestic violence, that we automatically want to call them as witnesses. But, and we should also be exploring ultimately when is child witness domestic violence about also looking for a forensic interview and getting that process started. But hopefully we probably want our investigators or responders to at least get a preliminary statement from kids at the scene. just with a minimal facts to find out if they observed anything so we know what our options might be. But this is a something that's got to be decisions that have to be made on a case by case basis. Because of course, kids left in an environment with domestic violence are exposed to increased risk. But kids who participate in a prosecution over the objection of a victim or when a victim isn't participating are also at risk. And those are things that have to be weighed on a case by case basis. Of course, we want to get photos of the victim, any injuries it suffered, what clothing they were wearing, what their demeanor was. We want to be getting photos of the defendant. We want to be looking for any injury they suffered, especially if they just might try to frame this as something that escalated or got heated or got out of hand. We want to be looking for those defensive wounds inflicted by the victim. What kind of injuries are on the defendant's extremities, the arms, the legs, things like that that are more consistent with defensive wounds, scratch marks, things of that. We also want to be looking for medical records. And we're going to be talking a little bit more about this when we talk about the medical hearsay exception. But ideally, what we want to be doing is we want to have at least some kind of medical provider that can be immediately available for that victim, not only so that they can get cared for, but so then there might also be medical statements that can be utilized later in a prosecution. In an ideal world, and again, ambulances have to be paid for by someone, so maybe this isn't always possible, but it would be wonderful if anytime there's a call for domestic violence response, that a ambulance or paramedic EMT could be concurrently sent out with law enforcement at the same time. And they wouldn't contact anyone, of course, or speak to anyone until the scene is secured. But then when that scene is secured, then they're immediately available and you don't have to wait for it. That might be really difficult to do in a lot of communities, but it can really help build up cases and get more care for victims, which is incredibly important. Other things we want to be talking about is, of course, when we're looking for injuries, try to do it in a well-lit room. Take close-ups of any injuries, try to use scales, do this in a trauma-informed way. Just don't stick a ruler up against the victim's bruise or things like that. Take photos of the neck and face, even if we don't see visible injury. And the other thing we want to do that doesn't always happen or isn't always sort of a consistent practice is we want to make arrangements with a victim to get follow-up photos 24 to 48 hours later. And there's a reason we want to do that. Is one, sometimes it takes that much time for bruising and other type injuries to develop. So if we want to memorialize it, we need to make a follow-up appointment with the victim later. But the other reasons that that's a good strategy or good practice to do is because when we make arrangements to proactively connect with the victim 24 to 48 hours later, um, hopefully when things aren't as emergent as at that initial response, we can have a better opportunity to talk to the victim about what their needs are, how we can help them, maybe dive deeper with them about the history and nature of the relationship, any sort of past incidents of abuse that may have been previously reported or never reported, and we can start building up a bigger picture of what's going on in this case. And sometimes that 24 to 48 hours later, sometimes the wagons are already being circled around the offender, but sometimes we still have an opportunity to reach the victim or that they still want help. And of course, being proactive, asking the victim about different symptoms, because there's a lot of things that victims might not be sort of think to tell us unless directly asked. All right. So I talked a lot about the history of the relationship and what's the evidence we can use to establish that. And why I want to talk about that and the sort of evidence that we can use to build the history of the relationship is, of course, if there have been previous incidents, we want to be looking up police reports. Some of those police reports might, the victim in the instant case or present case might have been the suspect in an earlier case. Those are records we want to look at too, and maybe we can sort of be looking at them with a different lens or a better understanding of a domestic violence dynamic. I know sometimes I've encountered a lot of victims might have public intoxication type offenses in their history, and when you explore specifically what happened, you find out that it really is domestic violence related. We want to be looking at the criminal histories of both parties anytime child protection services might have been called. we want to be looking at medical records too. And sort of the classic example of the relevance of this showing the history of abuse or helping us understand a domestic violence dynamic or cycle is the victim went to the emergency room 6 months previously, a year previously, and complained of a broken arm. And conversations with the victim now, or maybe through pieced together through digital history or text communications, show that that actually wasn't a broken arm from having fallen or accidentally tripped. It was something caused by an offender. We also want to be getting statements from the network, especially of the offender, but also of the victim too. What's their relationship like? What have they observed? What do you see? And sort of building it up. Because again, most offenders, they don't sort of spontaneously abuse someone, especially if it's a more sort of explicit or extreme exercise of force. Usually, what most offenders are doing in a domestic violence dynamic is they are sort of testing the boundaries of the victim and gradually pushing and pushing them until it's acclimated. And a way to illustrate this is probably one of the most extreme examples, short of homicide, of intimate partner violence is the act of strangulation. And most offenders don't strangle their victim on a first date. The reason being is because there's not going to be a second date. But instead, what they do is maybe it starts with really sort of subtle emotional abuse or put downs or efforts to isolate that, again, uh, push against the victim's boundaries but don't cross. But once that victim's boundary is pushed against, it moves a little further out. So then next time maybe there's a push or a shove against the victim. And that's sort of just accepted by the victim or endured by the victim. And what happens after that, instead of a push or shove, then it becomes a punch, then it becomes more and more until it finally builds up. And so again, before help is called, before the victim calls 911, before someone else is called 911, there's a probably large percentage or a big percentage that this isn't the first incident of abuse, but it's just the latest in an episode or cycle of violence and abuse. So we want to be looking ideally for the history that can establish this so that we can approach these cases not just as a one-off incident we responded to, but with a wider lens and a bigger picture of what occurred. And so, what can we do with this historical evidence? Well, of course, it can inform our charging decisions, whether it's charging stalking, whether there's prior incidents that where jeopardy hasn't attached, maybe prior cases that were dismissed that can be recharged, prior incidents that were never charged that were still in the statute of limitations. We can bring in as evidence of other crime under 404B type evidence, or we can sometimes, especially other incidents of witness tampering, witness intimidation, as evidence of the offender's consciousness of guilt or effort to sort of control the victim and cover up what they did. So what these incidents do is it gives context for what occurred. And these domestic violence cases, when we just sort of prosecute them in an episodic manner, they can be a lot more difficult, especially when the victim isn't participating, because it's a lot easier for the offender to sort of frame it how they want to, because most offenders aren't carrying a flag or a sign that says I'm an abuser. Most offenders and good defense attorneys are framing it as this is just an argument that got a little heated, that got hot, things got out of hand. We just lost control this one time, and it's a private matter. But if we can really show the cycle, you get to show more about why the defendant committed the crime, why the victim responded as they did. There's more context and more understanding, and more ability for the jurors to decide what happened. Now, one of these charging decisions I talked about is stalking. And I know we have folks from lots of different jurisdictions here. And if you take nothing else away from this presentation, well, there's two things I hope you take away from this presentation. One is forfeiture by wrongdoing, which we'll get to later. But the other is the utility of charging stalking, especially in an intimate partner violence dynamic. But in my experience, and I fell prey to this, and I'm as guilty as anyone, stalking is more often than not, I think, one of the most undercharged and under-prosecuted crimes in our country. And it's difficult for me to think of an intimate partner violence case where if we just scratch the surface a little bit, it's not also a stalking charge. And the thing is with stalking, it's something that takes this historical evidence we learn about different abuse that occurred and lets us widen the lens so that we're not just prosecuting with the perspective of a street level view, but we're prosecuting with that sort of satellite view. Instead of prosecuting from a picture of what happened, we're prosecuting the movie of what happened. And this is sort of consistent with stalking elements, and every jurisdiction look at your stalking statutes, but generally speaking, what most stalking charges consist of is a course of conduct that's going to be directed at an individual and causes some kind of impact on that person. Now, the impact can be either a fear of bodily injury. Some jurisdictions describe that impact as severe mental distress, severe emotional distress. But that impact on a person doesn't necessarily have to be a criminal incident. But really, sort of where the secret sauce or the magic of stalking in a domestic violence context is this course of conduct. In some jurisdictions, refer to this as repeated behavior, pattern of behavior. But generally speaking, what that course of conduct requires as a legal matter is at least two, I apologize for that typo on the slide, at least two instances of conduct committed over a certain period of time. An individual instance of behavior doesn't necessarily have to be illegal, but in aggregate, the pattern of behavior has to be intended to put the victim in fear of bodily injury or to cause severe emotional mental distress, however it's phrased. What this means and how I want you to think about domestic violence, or I'd ask you to think about domestic violence, is every time your police agency gets a 911 call for a domestic violence incident, let's say our offender punched the victim in the face. Think of it as you have 50% of a stalking case. If you can find another incident of behavior in the course of the relationship that was intended to put the victim in fear of bodily injury or cause severe emotional distress, you have a stalking charge. And a stalking charge is essentially going to be that thread that sort of ties all these different instances of abuse against a particular victim together under one prosecution or in one case. Sort of the comparison I sometimes make is a lot of you might do organized crime prosecutions, drug trafficking prosecution, things of that nature. And you're familiar or you have friends in your office who do those cases. And you know how sometimes RICO or corrupt organizations charges are utilized. They're utilized, there's a lot of different elements, and you can be, why don't you want to charge it? Because it opens the door to so much evidence that the offenders in those cases committed. A legally permissible charge of stalking can do the same thing in domestic violence, in a domestic violence. When you have a stalking charge and charge stalking, you basically have an opportunity to widen the lens of conduct that an offender perpetrated against a particular victim. And if the separate instances of stalking also independently constitute crimes, you can also charge them. So the example might be 6 months prior or 2 weeks prior or something, the defendant had punched the victim. And in the present instance, the offender had strangled the victim. Well, I would charge stalking because you have a course of conduct intended to put the victim in fear of bodily injury. But I would also charge under that stalking case the assault that happened a couple weeks earlier, as well as the stalking in the case that we're currently responding to. And then you have it all under one case, one docket, without having to ask the judge with the request to bring in the prior incident under 404B or trying to join cases or things of that nature. So, what can be a stalking related charge? And again, I want to stress there might be instances of conduct that may not be criminal independently, but become part of a stalking course of conduct that we want to include. But basically, anything an offender, a domestic violence offender, can perpetrate against a victim. It might be prior assaults, it might be prior fraud related or financial exploitation crimes, it could be property crimes, it could be image exploitation crimes. It could be a variety of ones, and sort of you see the range of it. Here's sort of one way I sort of like to think in domestic violence cases is stalking as the umbrella crime that covers all the other things that are happening in that intimate partner violence dynamic over a period of time. And it's the umbrella that brings all those crimes into one case and one charge. So we talked about guidance about the current investigation for what we're responding to, how to conduct a historical investigation. But of course, we also have to remember that in a domestic intimate partner violence case, the investigation doesn't stop just because someone is charged, but it should be ongoing. And this means sort of recognizing and trying to and talk to our investigators to follow up and having consistent, regular contact with the victim, finding out if the offender or the offender's network's been having contact with them. When you have an offender who's in custody, checking those logs and jail phone calls, as folks have mentioned, and trying to identify and document any non-testimonial statements about the victim, about the relationship, or things that have been happening. Other component we want to be doing in our domestic violence cases is building the record. Because a lot of times we want to be getting ready with all these different statements and evidence we bring in to sort of prepare and educate our court about the admissibility, especially if we have a court that isn't used to the practice of evidence-based prosecutions. And when the victim doesn't want to testify or judges just give up. Instead, let's start educating our judges, use pretrial motions. Ideally, this can not only help victim safety, it might also prevent intimidation, help us prepare our cases for trial, educate the judge, sometimes even expose our guilty pleas. Because again, defendants are trying to exert influence and pressure on the victim in an effort to get away with it. When they learn that's not successful, and there's a ruling from the judge that we're going to get to bring in statements, then it can be a way to sort of encourage guilty pleas as well. All right. So a big component in any sort of evidence-based prosecution is bringing in other statements from the victim into our current litigation or current case. And so we want to talk a little bit now about what makes a statement admissible if the victim is recanting, if they're minimizing or not testifying. And we have a national audience here, so what I'm going to be doing essentially is sort of gearing this towards federal rules of evidence and a national baseline. Of course, the rules and the nuances of your jurisdiction may vary. We do give this training individually in jurisdictions and gear it towards that jurisdiction specific laws. So if you have any sort of issues or questions, maybe about how a specific doctrine might apply in your jurisdiction, maybe there isn't a lot of jurisprudence developed on some of these topics in your jurisdiction, and you want to get some comparisons, please reach out. Um, so before we talk about how to get these statements in, we want to talk about where can we find admissible statements that our victim gave, that we can talk about strategies about how to get them in. Of course, we want to look at statements that our victims made on the scene. We want to be looking at 911 calls and these on-scene statements. It might be to laypersons, it might be to law enforcement. We also want to find out statements that our victim made to friends and family. And again, sometimes we think about talking to these friends and family of the victim about, oh, what has the victim said before it happened? But even after the police response, victims might talk to these friends and family about what happened. Or they might make statements about, man, my neck is really sore from where he choked me up the other night, or be making statements, or and when the police came, I called the police because, and they might be making these statements. We want to find out as many people as the victim talked to as possible, and then explore if there's going to be strategies to get the victim's statements to people in later. And of course, any sort of medical witnesses that may be there. Now, when we have a statement from the victim, of course, the next question is, well, how can we get it in? And really, there's what I'm going to sort of recommend or suggest here. It's not the be all and end all, but it's a useful analytical tool. It's the first question we asked, is it hearsay? Is this statement from a victim we're trying to get in, is it a hearsay statement? If the answer to that is yes, then we want to be looking at whether or not there's an exception to hearsay applies. And then the third thing is that Crawford analysis, whether or not the statement is testimonial. Now, practically speaking, we could have put this first. Is the statement testimonial? Then is it hearsay, or does an exception to hearsay apply? But this is just sort of the flow that I'm working with for this. Now, on that first question, is a statement hearsay? This is really a 101 rules of evidence analysis. And again, your rules might have little tweaks about how hearsay is defined, but here how it is distilled on a really basic level. A statement that someone is making, it could be verbal or it could be a non-verbal assertion. You're asked a question and you give a nod of the head or a shake of the head. That can be a statement that can be understood in context of the question. A statement that happens out of court. It's made by someone other than the person testifying. So technically, this could be the victim talking about what they told a police officer. It could be the neighbor about what the victim told them, or the police officer about what the victim told them, made at another time during testimony. Now, to be clear, a victim testifying about what happened to them, that's not out of court. A victim testifying about what they told someone about what happened, that is out of court, and that could be hearsay, but it depends. A lot of this is going to be contextually dependent. And the other prong for whether or not a statement is hearsay is it being offered for the truth of the matter asserted. And this is really where that context specific analysis comes in. Why are we trying to get the statement and evidence? Are we doing it to show not that the statement's true, but to why someone did what they did? Or are we trying to get the actual substance of the statement into evidence? Are we trying to show that someone had motive? The classic example is if the victim says, "Hey, I was cheating on you." We don't really care about the truth of whether they were cheating on him, but we're trying to get it in to show the motive of the offender to abuse him. Are the words important or the accompanying thoughts or acts? For the analysis, we go as to whether it was for the truth of the matter asserted. So I sometimes when we do this in training or in place, we have examples. We sort of talk about how this can play out. Nature of the webinar, though, we're not going to really do the examples here. The next prong we're going to be looking at is, does an exception to hearsay apply? And what we have here is this is not exhaustive of every kind of potential hearsay exception. And in some jurisdictions, if we're really sort of teasing this out, some of these aren't exceptions. In some jurisdictions, these things are defined as not being hearsay. But what I'm sort of offering here for simplicity purposes is this is the usual bucket of hearsay exceptions, if a statement is hearsay, that we're going to be using in our evidence-based prosecution practice. There might be more, especially maybe if we're trying to get digital records in, we're using business records exceptions, things like that, but that's not something we're going to be exploring in this context. But if we're trying to look for different exceptions that might apply to different statements a victim made. The most common one and readily used one in most domestic violence incidents is going to be that excited utterance exception, memorialized in Federal Rule of Evidence 8032. Components for that is we want to show that the witness had personal knowledge of something that was exciting or startling that provoked a statement. And most jurisdictions don't have a clear sort of bright line time limit about when that provocation between the declaration and the startling event has to happen, but the statement has to be related to the exciting, startling event. I suppose the classic example of this is the victim calling 911 and saying, "He just hit me." And that would be the sort of example of an excited utterance that we would have. Really, for intimate partner violence investigations, what we want to be doing is we want to be reporting the specifics of the victim's emotional demeanor, not the conclusion. A lot of times, maybe with body-worn camera, this is more apparent. But on some level, too, and what can make litigation a lot easier is if we get some sort of temporal anchor to when the event occurred versus when the statement is made, which doesn't always happen. And we shouldn't be expecting our victims to say, "Oh, yes, this happened 11 minutes and 47 seconds ago." But some sort of, yes, it's 9 p.m. when you're talking to me. This happened sometime after dinner. some sort of relation, or right before the police were called, something of that nature that can give us a time anchor to when the statement was made relative to when the event happened. The other example tool that we're going to have for hearsay exceptions is going to be that present sense impression. It's different than an excited utterance in that it has to be simultaneous or immediately after the event, no delay. So if the victim says, while she's on 911, he's hitting me right now, that would be an example of present sense impression. A lot of times we're going to be finding this exception applicable is if there's statements the victim made to third-party eyewitnesses that were there at the assault, such as children, neighbors, etc., especially ear witnesses rather than just ear and eye witnesses and things of that nature. Existing mental, emotional, or physical condition, it's a statement of the declarant's then existing state of mind, such as motive, intent, or plan, or their emotional or physical condition. Where this comes in, a lot of times in our intimate partner evidence-based prosecutions, investigations, if there's a statement made by the victim to a third party about the pain or injuries from the assault, they talk to their coworker or their family member the next day about how sore they are, then that can be evidence of the injury that was used as evidence as the injury caused by the assault, and going to be one of the things we need to sort of prove up our elements. Sometimes it can be statements by a victim to a third party if showing fear of the defendant. Now, not every jurisdiction finds a victim's fear of the defendant to be relevant. I know there's some jurisdictions, it's like just because the victim was afraid, it may not be relevant to the nature of the crime. My own jurisdiction, Pennsylvania, was like that. But in some jurisdictions, you can bring in evidence of the victim's fear of the defendant, and this exception is a good tool to be able to do that. Now, we want to talk about, and we're going to spend a couple slides talking about this one, is medical treatment or diagnosis. These are statements made in the course of medical treatment that are admissible through the medical provider. Now, where there's changes in some jurisdictions is that in some jurisdictions, the only thing the medical provider can testify about is what our patient victim said about how they were injured, but not who injured them. In many jurisdictions, the medical provider can talk about what the patient slash victim not only said about how they were injured, but who the injury was caused. And the reason for that is because, of course, the who caused the injury does have a medical purpose, because most medical providers don't want to release patients into an environment where they may be at further risk. But what this exception, and this is really, I think, can sometimes be a lot more useful than excited utterance. We always want to sort of urge medical care for our victims, not only because it's one, good for them to get help that they need, but because, again, those statements that are going to be made to a medical provider, whether it's our EMT, our paramedic, our emergency room nurse, or our emergency room doctor, those statements can be coming in under that medical hearsay exception, even if our victim is recanting, even if they're minimizing, or even if they're not testifying. What we want to do, though, and just probably a good practice and a way to sort of prevent defense arguments before they hit, is we want to make sure as much as possible law enforcement is not present during a medical exam, because then what sometimes a defense attorney might do is argue, well, this exam really wasn't medical in purpose, it was investigative in purpose, and therefore doesn't fall under the medical hearsay exception. So we want to make sure our officers aren't there. The other thing that we want to do, and I think we have a greater ability to do this than in my early days, again, with body-worn cameras, is the use of recorded recollection. The components of this is that a witness currently has insufficient memory, they once had firsthand knowledge, and a prior statement made or adopted by the witness when their memory was fresher. So if they give a statement maybe on body-worn camera footage or an interview that's going to be recorded about what happened, and maybe they're missing some details, or they take the stand and they just give I don't knows or I don't remembers, the recorded recollection can be one vehicle to get those statements in, as well as prior inconsistent statements. Witness can be testifying and they're subject to cross-examination about a statement. In some jurisdictions, though, a witness doesn't always have to be confronted about the inconsistent statement, but check in your jurisdiction. Um, what can be an issue in some jurisdictions is in many jurisdictions, the inconsistent statement, especially if it's memorialized, can be used for substantive and impeachment evidence. I know some jurisdictions say an inconsistent statement can only be used for impeachment purposes, but ideally we want this prior inconsistent statement. Now, these two vehicles, recorded recollection and prior inconsistent statements, these are usually the vehicles we're using when the victim does testify, but they're recanting or minimizing the intimate partner violence that occurred. All right, so we talked about in our statement analysis is whether or not a statement's hearsay, conducting that analysis, whether or not an exception to hearsay applies, and then the third analysis prong we have to jump over is whether or not the statement's testimonial. And as folks are probably already anticipating, especially for those with experience with this is the Crawford versus Washington analysis, which really starts with the limitations imposed and the rights guaranteed by the Confrontation Clause in the Sixth Amendment, and of course, which says in all prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. And what this means, and I should say what Crawford v. Washington recognized it to mean, is just because an out of court statement cleanly or neatly falls under a hearsay exception, if it violates the right to confrontation that's held by every defendant, it doesn't come in just because it fits under a hearsay exception. Now, what they're worried about is testimonial statements coming in that might fit under a hearsay exception. And the Crawford court began the analysis or discussion about what is a testimonial statement. And essentially, what it is, a statement, an out of court statement is testimonial if its primary purpose is for use in later prosecution. It's typically a more formalized statement. Those testimonial hearsay statements, when there's a hearsay exception that applies, they're only available when the person who made the statement's available for cross-examination, or that there is a full and fair opportunity for prior cross-examination. So that testimonial, let's sort of work out that definition. Again, it's something that's going to be more formal, usually definitely something made to law enforcement or one of their agents. And the primary purpose is to report facts for later prosecution. So a good that testimonial hearsay could still be admissible if the victim testifies, if the victim previously testified and there's full and fair cross-examination opportunity, or if there's a forfeiture by wrongdoing exception applies, which we're going to be exploring a little bit in just a moment. Non-testimonial hearsay, of course, that's the antithesis to testimonial hearsay. That's not covered by the confrontation clause. Non-testimonial hearsay can come in so long as there is an appropriate exception under an individual jurisdiction's hearsay rules. An example of a non-testimonial statement are going to be statements during an ongoing emergency. 911 calls fit perfectly into that bucket, or maybe those initial statements made to law enforcement in responding to an emergency. Casual remarks to others, statements made for purposes of medical treatment, which is why that medical hearsay exception is such a useful tool in our evidence-based prosecutions, and business records not prepared for litigation purposes. So we did talk about what sort of teased out what's non-testimonial. There was the two cases, Davis and Hammond from 2006, shortly after Crawford. Davis involved a 911 call seeking police assistance. That was ruled as non-testimonial. Hammond was statements of the domestic violence victim to police at the scene after the emergency ended were non-testimonial. So really what this means or started establishing is, again, a 911 call is generally speaking is going to be emergency in nature. It might evolve to investigative. Hammond sort of suggests that statements to police officers in response to an emergency has an initial limited window to be responding to an emergency before it takes an investigative character. But what I want to stress too with Hammond is, and again, you might have something that your police officer took a statement from a victim. The record in Hammond wasn't really developed as to why the officer believed that they were still responding to an emergency, and more careful efforts to develop that record could sort of establish that emergency purpose. So essentially, what this cases stand for is, do circumstances objectively indicate a primary purpose of questioning was to respond to an emergency or to record events relevant to future prosecution? Then there's also Michigan v. Bryant. The existence of the ongoing emergency is only one factor. In other words, in determining whether there's a factor, it doesn't have to be the only purpose why someone is doing the question. It just has to be the primary purpose. All right. So Crawford doesn't apply if there's statements not offered for the truth of the matter asserted. For admissions of the defendant, if there's evidence in civil proceedings, so if you have family court transcripts or something of that nature, and parole, probation, restitution hearings, and non-capital sentencing hearings. Here's a sort of flow chart we have about whether or not a statement's testimonial, which I'm not going to reiterate because I think we covered it, and I'm really excited to talk about forfeiture by wrongdoing in a moment. So I'm not going to break that down. I do want to remind everyone, of course, that Crawford is only one hurdle. If a statement is testimonial, Crawford doesn't apply, but you still have to find a hearsay exception that does apply in order for a statement to be deemed and held admissible. All right, so our next topic is going to be covering forfeiture by wrongdoing. I know we've got 80 people in our audience right now, a little bit less because there's myself and Katie. How many people have used forfeiture by wrongdoing in a domestic violence case or have done a forfeiture by wrongdoing motion? Can I just sort of quickly see in the chat if people have done it before? All right, I've seen, okay, so we have at least, I have a sample of, well, one person has done one person has witnessed, so we're getting a good sample, which encourages me because this is, I think, sometimes an underutilized tool. And sometimes when I'm giving this presentation live, like when I talk about this, light bulbs go off and they hear about it. So the concept of this is, of course, we just talked about when we were talking about Crawford and testimonial hearsay and non-testimonial hearsay. Of course, it's based on the premise in that Sixth Amendment right to confrontation that a defendant has a right to confront the witnesses against him. But just like other rights, that right can be confronted if the witness cannot be confronted due to the defendant's intentional wrongdoing. Similarly, like a defendant has a right to be present at trial, but they can forfeit that right if they abscond or during the middle of trial, if they're being disruptive. Similarly, their right to confrontation, it's not waived. If a defendant decides, or through their attorney, not to ask any questions on cross-examination, they're waiving their right of confrontation, but the right can be forfeited if the wrongdoing has made the witness unavailable. What this means conceptually is that if this forfeiture by wrongdoing exception applies, then you can bring in statements from the person who's unavailable, regardless of whether or not there's a hearsay exception reply, regardless of whether or not it's testimonial or non-testimonial. This is an old rule. It's been recognized as in the U.S. as early as 1878 in the case of Reynolds versus United States. And I'm not going to sort of give the background for Reynolds, but it technically should be called Reynolds versus United States too. It's a rule of equity or fairness. No jurisdiction has ever rejected forfeiture by wrongdoing. Many states have codified it. I should actually amend this slide because originally when this slide was created, when we said no jurisdiction is rejected, the caveat was there's only one jurisdiction that hasn't recognized it, which is different than rejected, and that was Maine. But as of last year, 2025, they've amended their rules of evidence to recognize forfeiture by wrongdoing. So now every jurisdiction in the United States not only has no jurisdiction rejected it, but every jurisdiction recognizes forfeiture by wrongdoing, either through some kind of codification, usually through their rules of evidence, or through some common law jurisprudence. So we'll start with the forfeiture by wrongdoing at the federal rules of evidence. This is an 804B. If you remember and remember back, what 804A covers are the different sort of bases of unavailability that have to exist before the different exceptions in 804B apply. And this exception, forfeiture by wrongdoing, it's one of the last in this paragraph, 804B6. And what it says is that a statement offered against a party that wrongfully caused or acquiesced, in other words, just let third parties do the dirty work, in a witness's or declarant's unavailability and did so intending that result, means those statements can come in. So really, if we sort of diagram what the elements are here, is if you have a victim unavailable or a witness, they're unavailable due to the defendant's wrongdoing, and the wrongdoing was intended, at least in part, to cause that unavailability. It means that that victim's statements are now admissible. So this forfeiture by wrongdoing, it's not really applicable if the victim is recanting or minimizing, but when the victim is unavailable, this forfeiture by wrongdoing is a possible tool. It applies to any potential witness who is unavailable. And check your own jurisdictions for the definition of what's available. But when it applies, as I mentioned, it opens the door to any hearsay, regardless of whether it's testimonial, regardless of whether it's non-testimonial. There's no need even for a hearsay exception. So the classic example might be is where a forfeiture, but I mean, relevance would still be an admissibility bar. But if the victim goes into the police station 4 days after the incident, talks to a detective, gives a full recorded statement or unrecorded statement, actually, about the nature of abuse and history of abuse. That's obviously something that's going to be testimonial. There's no hearsay exception that applies if forfeiture by wrongdoing is available in a particular case because that person is unavailable. Then at trial, all we have to do is just press play on that recording. This could also apply to grand jury testimony, assuming secrecy requirements have been released or lifted. Then you could just sort of read the transcript from a grand jury presentation if there's a forfeiture by wrongdoing exception that applies in particular litigation. So when does it apply? And a good case to sort of reference, and for every domestic violence prosecutor who's going to be utilizing forfeiture by wrongdoing to keep handy, is Giles versus California. This is from 2008. I've never gotten a satisfactory answer whether Giles is a soft G or hard G, but I've always used a soft G to pronounce it. But what happened here, it was a domestic violence related homicide. The defendant had shot his ex-girlfriend in a trial. He was claiming it was self-defense. To rebut that claim of self-defense, the police wanted to bring in a call that happened 3 weeks earlier from the victim, where she called 911 and said, "Hey, he's beating me, he's abusing me." And what the California courts did is, "Hey, look, the victim's unavailable. She's dead. She's unavailable because he killed her. So forfeiture by wrongdoing applies, and the prosecution can bring in the 911 call from 3 weeks prior." And it was affirmed by all the appellate courts in California. When it came to the US Supreme Court, what they said is, well, there's one thing missing when we're doing forfeiture by wrongdoing. There has to be some evidence of record that when the defendant made the committed the wrongdoing that made the victim unavailable, there had to have been some intent to make the victim unavailable as a witness. It's not enough evidence to prove that the defendant killed the victim. You can't then make the step that he intended. There has to be some sort of evidence developed, so it was remanded for that evidence to be developed. But in developing that record, they recognized that, hey, look, earlier abuse or threats of abuse intended to dissuade the victim from resorting to outside help are highly relevant to that inquiry. The inquiry being whether a defendant killed with the intention to make a witness unavailable, as would evidence of ongoing criminal proceedings at which the victim would have been expected to testify. In other words, what Giles was recognizing, that when we're making this analysis of the intent to make a witness unavailable, we don't have to throw out common sense. We can make inferences from the nature of the domestic violence relationship as well as the history of the specific domestic violence relationship. So GEOs is definitely a good thing for you to review if you've never done so in your life or career. Forfeiture hearing, if you haven't had a hearing, because this is a pretrial admissibility hearing, like most of these admissibility hearings, it has to happen outside the presence of the jury. Standard in most jurisdictions is going to be preponderance of the evidence. Washington and New York require a clear and convincing standard. But in this admissibility determination, just like any admissibility hearing, the rules of evidence don't apply. So in proving the wrongdoing and the intent to make them wrongdoing, you get to use hearsay, you can use affidavits, you could just call your police officer to talk about all the different evidence and sort of collect it. And the statements you wish to introduce are also admissible. You might want to consider using a victim behavior expert to educate your court, or at least sort of make a record about victim behavior, domestic violence, victim dynamics and responses. Um, and of course, it's going to be depending on availability. Oh, wait, I have problems doing that. At the forfeiture hearing, recognize that Rule 104A. Again, if your judge is looking for witnesses to be called or thinking that hearsay has to be on, or hearsay rules have to be recognized, that the check for your jurisdiction has an equivalent of 104A, which talks about it doesn't, rules of evidence not applying. I know this does, if you're ever, anyone here is from Utah, this doesn't apply, that you don't have strict applicability of your equivalent of 104A for forfeiture by wrongdoing hearings, although your burden still is preponderance of the evidence. But also, what this means too is when you can be using circumstantial evidence and inferential evidence to show that the defendant committed wrongdoing and that the wrongdoing was intended to make the witness unavailable. Usually it's going to be that circumstantial evidence that you're going to use to show that intent to make the witness unavailable. And your courts, it might be sort of counterintuitive, or your courts are uncomfortable with that. But look, you can use circumstantial evidence to prove people guilty beyond a reasonable doubt. You can certainly use circumstantial evidence to satisfy an admissibility standard by a preponderance of the evidence. So proof at hearing, you use unavailable witnesses hearsay. That's in Davis v. Washington. That case I think we referenced earlier. And the intent to make, and this is a good sort of ruling out of the Second Circuit, the intent to make the witness unavailable need not be the only motive. The defendant can have lots of motives, but if one of the motive is to make the witness unavailable from reporting or testifying. So what's the evidence of wrongdoing? Where do you find that? You can find it, of course, jail calls are going to be a real gold mine for this sort of thing. And the wrongdoing, it might not just be intimidation or tampering. It can also be manipulation. And when we get the evidence about the love bombing or the things like that, or promises of hey, look, I'm so sorry this happened, or I'm going to go to rehab, or we're going to have such a great life, that's wrongdoing that you can infer was intended to make the witness unavailable. Prior civil or criminal cases, if you have a lot of cases where the victim dropped off or didn't testify or recanted, that's pretty good evidence in this case, inferences you can draw, and you can prove it circumstantially, of course. If the witness is unavailable, they're just not in court. Be prepared to show reasonable efforts to produce your witness. In other words, this isn't something you want to have just made the effort to find your witness the day prior, but that you can show the court, hey, look, we had multiple ways to try and contact or locate the witness, and none of them have worked. We issued a subpoena. We've tried to keep in regular contact with the witness. We sent someone out to the last location to see if they're going to be available. We've heard these statements from the witness that they don't want to appear or refuse to appear. You don't want to wait until the eve of trial. Of course, you do not need to ask for a bench warrant or material witness because, again, you have to show your reasonable efforts to produce a witness. As a prosecutor, it's not reasonable for you to get a bench warrant for your domestic violence victim. And the reason why it's not reasonable for you to pursue those sort of extra level measures is because if you do, you're going to have a victim that's going to not want to reach out for help the next time they're in danger or trouble, a victim who's really at high risk and could be killed, and probably a victim who isn't going to be really participating or made safer. So for the public interest as a prosecutor, it's again 99.9% of the time never justifies a material witness petition or a bench warrant for a victim because it does more harm than good, and that is awful prosecutorial practice to get bench warrants for DV victims. So you want to litigate forfeiture by wrongdoing. Again, you don't always know when your victim's not going to appear, but you should ideally sort of keep a forfeiture file handy, maybe with like some black letter memorandum on law, and just sort of the instances that keep your intent up as to why they might not appear, so that on the fly you can sort of present that when necessary. I also want to point out the forfeiture by wrongdoing, the unavailability can occur just not only when they don't show up to court despite your reasonable efforts, but also they assert some kind of privilege, like maybe a Fifth Amendment privilege. They have just give either real or what is believed to be faint losses of memory. That also qualifies as unavailability. And so there's other sort of platforms of unavailability besides them not showing up for court. All right, so trial strategies. We're at the home stretch here, and I want to take us home here. We want to keep throughout the case, keep our focus on not what the victim did and not let that focus switch, but what did the offender do? How did the offender cause these challenges that the victim is facing? And general strategies we want to do is we want to be building our case around what the offender did, how the offender caused unavailability of the victim or the lack of participation, and trying to give the jury as big a picture as possible. Um, we talked a little bit about other acts. Yeah, you can use 404B, but of course, efforts to manipulate, intimidate, or tamper with the victim, that's good evidence of consciousness of guilt. And if you have a standard jury charge in your jurisdiction for that, and you have evidence of it, I'd be asking the jury to be charged on that component. Do our pretrial litigation efforts, which we talked about earlier. Listen to the defense. Anytime the defense files motions or talks to us about why our case is so awful, be grateful for it because it gives us a great chance to understand what the defense is doing, and we want to try to pay attention. And so we know what to respond to. If we know there's potential defense witnesses, even character witnesses, try to go out and talk to them as quickly as possible. Talk to the defendant's mother, talk to the defendant's family, see if they have everything to say. If they tell your investigator to go pound sand, that's great. You've got a great sort of point on cross-examination that they didn't want to tell the participate. They just wanted to get their family member home, regardless of what the truth is. And if they do talk to you, great, you've got a heads up. Jury selection, basically, we want to be confronting our problems or challenges heads on, finding out if our jurors think there's such a thing as private crime, or if it matters, or if they can still follow the law, even if the victim isn't able to participate. Find out how many panel members, if you can do so, might have family members or friends who are victims of domestic violence, and whether that was something that was reported or disclosed right away. The opening statement, again, I think we want to sort of keep it fluid and being careful not to predict the victim's testimony, because recantation, or sometimes even when we think we have a victim who's not participating, participation can happen at any moment. And we want to be focusing on the evidence of the guilt and talking to the jury about the sort of challenges and our barriers that our victim has in participating. When victims do take the stand, and they're recanting or minimizing, we really want to we don't want to sort of exploit our power dynamic with them because that's not really as helpful. We don't really want to have an aggressive cross-examination, but just see what we can elicit that's going to help with them. Find out if we can elicit from them those kinds of circumstances that help the jury understand about why they didn't really have a choice. Hey, who pays the rent? Who takes care of the children? What kind of support or family members do you have? Let the jury know about all these challenges the victim faces, and that we're not, let the victim understand, even if they're being adversarial with us, that we're not their enemy and we're not the ones there to hurt them. So we want to remember that we're with the power. And again, if we're sort of seen like abusing this victim, it really can a lot of times boomerang or backfire against us. So help the jury understand a victim's recantation is understandable. Maybe be using things like expert testimony, victim behavior experts, And again, try to show the evidence of the defendant influencing or tampering the victim and arguing that as consciousness of guilt. So what we want to do is we want to support victims to enhance their ability to participate at trial, thoroughly investigate and document evidence in intimate partner violence cases, keep our focus on the offender by charging or introduce evidence showing a cycle of abuse, and anticipate defenses and effectively counter defenses with evidence and trial strategies. So, folks, here's my contact information. I thank you, everyone, for listening and staying with us. It looks like we we haven't had much drop off, judging from the participants that are here. Really enjoyed presenting, and please, if you have any questions or you want samples of some of those motions I referenced, please don't hesitate to reach out. I would be happy to share with you what we have and help you in any way we can. Thank you, everyone. It was wonderful having you, and thank you all for what you do.